say verdict, we have the jury on the way up. We need Mr. Colley, so that would help. Somebody getting Mr. Colley. Is somebody back there?
Okay, so they come that way.
This is directed towards everybody in the audience. I know these things can be emotional. I understand that, but I don't want any outbursts in the courtroom. If you feel that you might have a problem containing yourself when the verdict with regards to this portion of the trial is read, you might want to remove yourself at this point. Anybody who does have an outburst in the courtroom will be removed, so I just want to caution everybody about that ahead of time. When the jury comes up here, I will review the verdict for legal sufficiency, then I will publish the verdict, and then I will poll the jury in compliance with Section 7.12 of the Florida Standard Instructions on Criminal Cases, which is a different polling that is than for a regular guilt phase portion of the trial. We'll go from there. Yes. Say this also while we're waiting on the jury. Lawyers did a superb job. I just want to say congratulations and thank you to all the lawyers for the job that was done by both sides. Both sides were well served by their counsel, and counsel, in addition to very assertively representing their interests, clients' interests, also acted very professional. It's greatly appreciated. It doesn't always happen. Greatly appreciated. People can take lessons from everybody in this case on how to try a case. All right, we'll go ahead and bring the jury in, please, Mr. Gregg. review it for legal sufficiency, and then publish the verdict. Mr. Colley, if you'll please stand with your counsel and partner to the jury's verdict, please. I will read this verdict. In the state of Florida versus James Terry Colley Jr., case number 15-1248 CF, verdict as to sentence on count 1. We, the jury, find as follows as to James Terry Colley Jr. in this case. Section A, aggravating factors as to count 1. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the following aggravating factors. 1. James Terry Colley Jr. was previously convicted of another capital felony or a felony involving the use or threat of violence to a person. Yes. Number 2. The first-degree murder was committed while James Terry Colley Jr. was engaged in the commission of a burglary. Yes. Number 3. The first-degree murder was especially heinous, atrocious, or cruel. Yes. Number 4. The first-degree murder was committed in a cold, calculated, and premeditated murder without any pretense of moral or legal justification. Yes. Number 5. The first-degree murder was committed by a person subject to a domestic violence injunction issued by a Florida judge, and the victim of the first-degree murder was the person who obtained the injunction. Yes. Section B, sufficiency of the aggravating factors as to count 1. Reviewing the aggravating factors that were unanimously found to be established beyond a reasonable doubt, we, the jury, unanimously find that the aggravating factors are sufficient to warrant a possible death sentence. Yes. Section C, mitigating circumstances. 1 or more individual jurors find that 1 or more mitigating circumstance was established by a greater weight of the evidence. Yes. Section D, eligibility for the death penalty for count 1. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt outweigh the mitigating circumstances established as to count 1 first-degree murder. Yes. Section E, jury verdict as to death penalty. Having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt, and that the aggravating factors are sufficient to warrant a sentence of death, and the aggravating factors outweigh the mitigating circumstances, we, the jury, unanimously find that James Terry Colley Jr. should be sentenced to death. Yes. Signed and dated by the foreperson on this date. Verdict as to sentence on count 2. We, the jury, find as follows as to James Terry Colley Jr. in this case. Section A, aggravating factors as to count 2. We, the jury, unanimously find that the state established beyond a reasonable doubt the existence of the following aggravating factors. 1. James Terry Colley Jr. was previously convicted of another capital felony or a felony involving the use or threat of violence to a person. Yes. 2. The first-degree murder was committed while James Terry Colley was engaged in the commission of a burglary. Yes. 3. The first-degree murder was especially heinous, atrocious, or cruel. Yes. 4. The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. Section B, sufficiency of the aggravating factors as to count 2. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt, we, the jury, unanimously find that the aggravating factors are sufficient to warrant a possible sentence of death. Yes. Section 3, mitigating circumstances. 1 or more individual jurors find that 1 or more mitigating circumstance was established by the greater weight of the evidence. Yes. Section D, eligibility for the death penalty for count 2. We, the jury, unanimously find that the aggravating factors were proven beyond a reasonable doubt. Let me rephrase that We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt outweigh the mitigating circumstances established as to count 2, first-degree murder, yes. Section E, jury verdict as to death penalty. Having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt, that the aggravating factors are sufficient to warrant a sentence of death, and that the aggravating factors outweigh the mitigating circumstances, we, the jury, unanimously find that James Terry Colley Jr. should be sentenced to death. Yes. Signed and dated by the foreperson this date. If you want to be seated, I will poll the jury. Ladies and gentlemen, I will be asking you each discharge you as jurors in this case. I know you're tired of me reading instructions to you, but I do have one more for you. Ladies and gentlemen, on behalf of the parties, the lawyers, and the people of the state of Florida, I wish to thank you for your time and consideration in this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases such as this one. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. The lawyers and their representatives are not permitted to initiate any communication with you about this trial. However, you may speak to the lawyers or anyone else about the trial if you desire. You also have the right to refuse to speak with anyone if you desire. Your requests may come from those who are simply curious or from those who might seek to find fault with you. It will be entirely up to you to decide whether to preserve your privacy as a juror. What that means in sum is that no one can force you to talk about your discussions, your private discussions, your deliberations, other than the court order. However, you are free to discuss your discussions, deliberations, or anything else that occurred during this case if you desire to do so. That's entirely up to you. The lawyers, however, are prohibited, and their representatives are prohibited from initiating any communications with you about your discussions, your deliberations, and your participation in this case. But if you desire to speak with them, of course, you are free to do that. So it's entirely up to you. I do want to thank you on behalf of everybody here in the courtroom. I know this was not an easy case. We asked a lot of you, but we do greatly appreciate it and cannot get to this part of the proceedings without folks like you coming down here and serving, not like you had a choice. But nonetheless, we do greatly appreciate your service. You will get a letter from me in the mail. In addition to thanking you for your jury service, there's also a telephone number and an email address there. And it asks if there's anything that you can think of that we can do to improve the jury experience, to let us know, and I do take those very seriously. Those comments come directly to me. So if you have any comments, please feel free to send it to that email address or call that number. And like I said, they all do come directly to me. You will be excused from jury duty. You will have a 1-year exemption now from jury duty. After all this, you probably should get a lifetime exemption, but it is only 1 year by law. So if any of you get any summonses for jury duty in the next year, notify my office and we'll take care of that for you. With that, I will ask you to remove your jury buttons, first of all. The clerk always wants me to secure those so you don't lose them. And Mr. Gray is going to escort you to get your belongings. And thank you very much, folks. Leave your notes here. They will be destroyed as soon as we're done with the proceedings today. And again, thank you very much. Have a good day. Everybody else, please. Seated. The next thing we need to do in this case is a Spencer hearing. After I order a pre-sentence investigation from the Florida Department of Corrections. So, Madam Clerk, if you can send an email to the Florida Department of Corrections to begin a pre-sentence investigation. Mr. Colley, the Florida Department of Corrections will conduct what's known as a pre-sentence investigation. They'll be notifying your lawyers to see if there's any statements that you all want to make as part of that pre-sentence investigation. I do plan on conducting a Spencer hearing in about 45 days. We should get the PSI back by then. So everybody get your calendars out. How long do you think we will need for a Spencer hearing? Half day, full day, couple of days?
No, Your Honor. I would think that if you set aside a morning, I would imagine that would be probably sufficient.
Okay. Let me put some dates out there to you all. How about the morning of October 2? That's about 40 days out. Another option would be the afternoon of October 12.
I can't speak for Mr. Shoemaker, but this second is completely open for me.
State.
Either of those are fine.
Okay.
October or September?
October. Mr. Shoemaker, do you want to check?
Well, Your Honor, I have depositions on another case on the 2nd, but I can have somebody from the office.
Okay, let's set it for 9 o'clock on October the 2nd. And if there are any post-trial motions to be filed, I know there typically are, in addition to putting them in the e-file or filing them in the e-file, e-portal, I guess it's called. If you could forward them to my office as well, so I can see those and see if a hearing needs to be set on any of those motions. And obviously those will be done in the next couple of days or so. So October 2nd at 9 o'clock will be our Spencer hearing. I will send an order out to that effect as well. I'm going to ask for memoranda on both sides approximately 10 days after the Spencer hearing. So at that Spencer hearing, anticipate that I'm going to ask for that. And if you need more time or it falls during a holiday, we can talk about that. But October 2nd, 9 o'clock for a Spencer hearing. As soon as we get the pre-sentence investigation from the Department of Corrections, we'll send it out to your office via email. Okay, anything else we need to take up before our next hearing on this?
Mayor.
No, Your Honor.
Okay, thank you. Mr. Palmer, the deputies,